Good morning.
Good morning.
I guess everybody's not in as yet because I only see one person. That's you. I guess we could give them a couple minutes.
Yeah, sure. I'm trying to sort out my audio anyway, so.
Okay, so I'll give them about 10 minutes.
Okay, thank you.
All right, thanks, Jack. Good morning, Ms. Sands. We just said we'll give the others a chance to come in, so as soon as they get in, so either that or 10 minutes the most.
Okay, no problem. Morning.
Good morning.
Good morning, Miss Francis. We're just waiting on one more person and then we'll start. We should be getting no later than 9:40.
Yes, ma'am. Thank you. I have a question. Please. In the book, I noticed that like the chapters they said that you would be covering is 10 to 14.
Right.
But I don't see a chapter 14 in my book. I don't know if anybody
Okay,
else.
I was just wondering if I had a different book too, but I guess they must be
left out of a chapter.
They must left out a chapter or they adding something to it. I don't know. I'll find out. Let me find out and then I'll let you know as well.
Thank you.
All righty. Hello?
Hello.
Okay, it seems as if the 4 units are there. It's just that they may have mistakenly have them numbered because we're only doing 4 units and we would be covered all of the units. Their unit 14 is actually what our unit 13 is. So we're covered for all the units up to 13. Okay.
Okay.
Okay, so just to confirm the register, I have Leah Lowe, Ariana Sands, and Relicia Francis.
Yes, ma'am.
Yes,
Okay.
ma'am.
All right, so just a recap from last week. We have what the trustee has a general duty to do.
To account for trust property.
Right, and what is the trust period usually? Where we'll have to do the accounting.
Hello?
When is the trust period?
Hello?
Hi, can you hear me?
Oh, I can hear you now. I was saying Melissa Sands.
Oh, Melissa Sands, sorry.
Mhm.
Okay, it's not Ariana Sands.
No, my daughter changed the name when she was on.
Okay, sorry.
No problem.
All right, Melissa Sands. Yes, it was Melissa Sands last week. Okay. What is the period for the trust accounting?
Is the accounting a year that traditionally it can be set to match the anniversary date that the trust was created, or it could just be the calendar year or whatever is decided by the trust instrument.
Right, but once they decide that, what is important about that?
Being consistent.
Yeah, because it shouldn't be changed unless what?
Unless they decide, everyone decides to change the date, or you inform the beneficiaries.
Right, so it should be authorized by the trust instrument if you want to change it, right?
Oh, okay.
Yes?
Yes.
Yes.
Okay, what about the accounting records? What is reliable accounting records? What they calling that? For a trust?
They include like documents and receipts that back up what's found in statements that are prepared. It's easy to understand, well, correctly noted so that you can understand it when you go through it. And you could take a look and it gives an accurate snapshot of where the trust assets are.
At a particular point. And how long should we keep them? What's the minimum period for them to be retained? The trust? 5 years. Okay. Where do we get the trust income from? The income of the trust
Interest on deposits, dividends, rental income.
And loans.
And who's the income usually for in a trust?
The beneficiaries.
Beneficiaries.
Right, but we have 2 types of beneficiaries in some trusts, eh? Who are the 2 types we have?
Income and capital.
And so when we have income beneficiaries and there's income from the trust, where that goes, who that goes to?
The income beneficiaries.
And when do we decide as a trustee where charges or expenses should be taken from, either capital or income? How do we decide that, or is that set out for us?
It could be in the trust instrument.
It could be in it.
But what happens with that?
I think even though, if I understand correctly, which I hope I do, even though it could be in the trust instrument, the trustees still have the power to use their discretion to decide on that.
So it could, if it's not there, it may be directed by the terms, but they have discretion and they can decide which account they'll take it from, eh? What do we consider capital of the trust? And the expenses related thereto.
Capital would be the trust property.
Right. Example?
A home.
Anything
Stocks,
else?
bonds.
Yeah. And who gets this benefit?
The capital beneficiary.
And what is the advancement? What is advancement in a trust?
Any large payment or distribution from the capital.
And who was it paid to?
Beneficiary of the trust.
Capital beneficiary.
A capital beneficiary only, eh?
Right.
What about appropriation?
So that's the trustee's duty or action to appropriate where need be.
So
to, I guess, distribute the trust assets.
Okay, so is this their discretion, or how is appropriation done?
It would be inside the trustee.
Yeah, trust instrument.
So where it's not in the trustee, what could happen?
Then they could use that discretion to distribute.
No,
the funds of beneficiaries is required.
Right, you need the beneficiary's consent if there's no power to appropriate in the trust instrument, yes?
Yes.
Okay, so I think we have unit 10. Y'all know that well enough now. We pick out the salient points in that one, okay? Y'all had to read through of unit 11 yet?
What's your 11 chapter?
Trust investments. That's what you have as unit 11?
That's what I have. Yeah.
General principles of trust accounting.
We just did general principles of trust accounting in unit 10, eh?
Yeah, my unit 10 is general principles of trust accounting too.
Mine was numbered differently, so I just was,
Okay, so now you should have, I guess, your investments maybe 10, eh?
12.
12, okay, so we're on trust investments now. So you probably have the same book they have. So 11, we're on 11 or 12, according to the book you have.
I'm on 12, trust investments.
Right. So after we would have completed this unit, you should be able to understand the powers of investment in this trust instrument, understand the statutory powers of investment, and obtain information on the law relating to trustees and investments. Okay, who will begin reading for us today?
I'll start.
Thank you.
Trustees invest trust funds in order to provide an income for the income beneficiaries or capital for capital beneficiaries. The trust instrument often provides express powers of investment to the trustees. In the absence of these express powers, or where such powers may be limited in terms of the various ways trust funds may be invested, the Trustee Act 1998 provides guidelines to trustees on the investing trust funds. At the center of investing trust funds is the trustee's goal of protecting and preserving the trust from needless loss and fully realizing the returns on the investment that may be beneficial to the trust in meeting the needs of the income and capital beneficiaries. The standard of care for trustees in respect of their duties was stated in Spite versus Gunn, which is to take such as an ordinary prudent man would take if he were under a duty to make the investments for the benefit of others for whom he felt morally bound to provide. In the case, Lord Watson explained that, as a general rule, the law requires of a trustee no higher degree of diligence in the execution of his office than a man of ordinary prudence would exercise in the management of his own private affairs. Yet, he is not allowed the same discretion in investing the monies of the trust as if he were a person sui juris dealing with his own estate. Businessmen of prudence may, and frequently do, select investments which are more or less of a speculative character, but it is the duty of a trustee to confine himself to the class of investments which are permitted by the trust, and likewise to avoid all investments of that class which are attended with hazard. In Cowan versus Scargill, 1984, 5 of the 10 trustees of a mine workers pension fund refused to accept an investment plan submitted to the trustees by a panel of experts on the ground that the proposed investments were in energies which were in direct competition with the British coal mining industry, and that it was the policy of the National Union of Mine Workers, who had appointed the 5 trustees, not to invest in competing industries. The court held that the trustees would be in breach of the trust if they failed to adopt the recommended investment strategy, were not entitled to base their investment decisions on purely ideological grounds, and the principle established is that it is the primary duty of the trustees in deciding how and whether to invest trust funds is to act for the benefit of the beneficiaries and in the best interest of the trust, both present and future. And if the purpose of the trust was the provision of financial benefits, a power of investment ought to be exercised in such a way as to yield the best financial returns by way of income and capital appreciation, McGarry VC said. Trustees may have strongly held social or political views. They may be firmly opposed to any investment in South Africa or other countries, or they may object to any form of investment in companies concerned with alcohol, tobacco, armaments, or many other things. In the conduct of their own affairs, of course, they are free to abstain from making any such investments. Yet under a trust, if the investments of this type would be more beneficial to the beneficiaries than other investments, the trustees must not refrain from making the investments by reason of the views that they hold. It is recommended that where trustees may be doubtful of their duties and responsibilities regarding the investment of trust funds, they should seek appropriate legal advice. Nessel versus National Westminster Bank, 1993.
Okay, so that's, now your introduction is a bit longer than this book I have. So what they've done is expanded on the information I have here, and they've actually opened up the cases that they would have referred to initially in the book I have. Everyone has the same one that she has?
Yes, I do.
Okay, good. So at the center of the investing the trust funds, the trustees' goal is to protect and preserve the trust from needless loss and fully realize in the returns on the investment. Now, what was key that they pointed out is, as much as the trustees decide how and whether to invest trust fund, they are to act as a prudent man would in his business. So he cannot now insert his moral compass into the trust where it would be like where they draw, for example, he may be against tobacco or alcohol. If it's beneficial to the trust and it's not competing with the trust interests, or as in Cowan and Scargill, where it would have been competing directly with the business at hand, then he is to go ahead and make the investment. It can be that he inserts his own personal feelings into setting out the trust investments, but it cannot be in direct competition with the trust. So in Cowan and Scargill, what happened? What was the principle that they got from that? You all read it just now? Was she just read?
That the investment wasn't for the benefit of the beneficiaries?
What happened with Cowan? What they said, the Cowan and Scargill, what happened there? This was a what type of company?
A mining.
Right, it's a coal mining company, right? And what was the trustees proposing to do? Where they wanted to invest the trust funds?
In energies
that would directly compete with the purpose of
industry.
Right. So would that be in the best interest of the trust? If I'm selling shoes and you selling an alternative tennis. So it's walking shoes I'm selling, but you're selling tennis. Should the trustees of my shoe company now invest in the walking tennis? If you directly competing with me, when you invest in them, what you've done?
You've given them a greater advantage over your company.
Taken away from them.
So your duty is to do as what a prudent man would do. So if I'm in business, would I invest in someone else's business, or I'm going to try to promote my business more?
Yours over theirs.
Right. So if he's making investments, he wouldn't want to invest in something that would compete with the trust itself. So we'd invest in something of another nature, or we would invest in something that promotes the trust, more or less. So what is the principle they say in the trustee deciding how and whether to invest trust funds?
They have to act in the benefit of the beneficiaries and the best interest for the trust, both present and future.
Right. So where they're doubtful, what they should do?
Seek legal advice.
Right. So the trustee at all times must protect and preserve. He must be, what is the standard of care? Where's the standard of care set out? In what case?
Spite and Gaunt.
And what is the standard of care?
To act as a prudent man would if they were making investments for any other person that they're morally bound to.
Right. So just as you would for anybody else you were morally bound to. So say, for instance, in the case of your children, you're making sure that you are protecting them. So as you would for your own, likewise, as trustee, you have to put yourself in the same place. Now, the standard of care is very important in the trust for you to know what is the standard of care. So you should make sure you know that one back and front. And spite and gone is a very important case of where you get that principle from.
I have a question, please. Just so that I understand, using this case with the mine workers and being presented a plan to invest in energies that was in direct competition. If there was an instance that the trust instrument had it noted that you can invest in a similar industry as long as it's not in that particular country, then that would be okay, right?
Or competition.
Okay. So
but now if it's set out in the trust instrument, that's different, eh? Then
right, I'm just trying to make sure I'm understanding.
Right. So in this instance, the trustee was making the decision, eh?
Because the trust instrument it has already laid it out clearly what the decision should be, right?
Right. So if the trust instrument doesn't provide, then what happens?
The trustee could use their discretion.
Right. And so their discretion must be then what? What the principle we get from Cowan and Scargill?
To make sure that it's benefiting the trust present and future.
Right. And that's for the benefit of the beneficiaries and in the best interest of the trust, both present and future.
Okay. Thank you.
Yeah. So you see how you'll answer a question now if you were to be asked. You'll pull the principle back and you will say what the trustee has to do. So where there's no clear or express power or it's set out in the trust instrument, as set out in the case of Cowan and Scargill, the primary duty of the trustee in deciding how and whether to invest trust is trust funds is to act for the benefit of the beneficiaries, both present and future, and in the best interest of the trust, yes?
Hi, Ms. Dawson, I have a question, please.
Okay.
So in the case with Spite versus Gun, the principle is there for the standard of care?
Right.
Okay,
you get the standard of care from there. And what is the standard of care?
Is to take such care as an ordinary prudent man would take if he were under a duty to make investments for the benefit of other persons for whom he felt morally bound to provide.
Right. So what is good for you to know is to pull these principles out and then associate the case with it. And it shows you understand the concept well enough.
Okay.
So that makes your answer much more comprehensive, and you get a little extra points in that as well, eh?
Okay.
Any other questions? So if the trust instrument doesn't provide express powers of investment, then the Trustee Act provides guidelines to the trustee on investing trust funds, right?
Yeah.
Okay, let's continue.
You want me to continue or?
Yes, please. Let's see how much we have here. Let me see before I tell you to go ahead. So everybody, yes, you can continue up to express powers of investment, eh?
Okay, sure.
Thanks.
Trustees' investment duties. In trust law, trustees are expected and required to act as a prudent man of business with regard to the investment of the trust property on behalf of the beneficiaries of the trust. To supplement this standard of care, trustees must perform certain established duties in relation to the investment of trust funds, namely, 1, a trustee must not invest in risky or hazardous investments unless expressly provided in the trust instrument. 2, a trustee must have full information about an investment before he makes it. 3, a trustee owes a higher standard of care where it is a professional trustee carrying on the business of providing advice and managing trust funds. Bartlett and others versus Barclay Bank Trust Company Limited, 1980. 4, a trustee with the power of investment should undertake periodic reviews of the investments held in the trust. The reviews should take place at least annually. Nestle versus National Westminster Bank PLC, 1993. And 5, where the purpose of the trust is to provide for the financial assistance of the beneficiaries best interest will usually be their best financial interest. Cowan versus Scarrow, 1985. It has been decided by the UK courts that only where moral considerations do not affect the financial interests of the beneficiaries could they be taken into consideration by the trustees. Harris versus Church Commissioners for England, 1992.
Okay, so in the trustee's investment duties, again, he's expected to act as a prudent man of business with regard to the investment of trust properties. So the standard of care is now supplemented with these established duties in relation to investments of trust funds. And the standard of care is now supplemented with what? The trustee must not invest in risky or hazardous investments unless expressly provided in the trust instrument. So what could be risky or hazardous to the trust outside of regular investments? What is risky in investments?
I would say stocks.
So some stocks may be risky, but what is a risky stock? What you may have? What they have? Some hedge funds where you may take a chance because you don't know that you could lose all. Are you to take those kind of chances with trust funds?
No, unless.
Not unless expressly stated, eh?
Yes.
So you can't take their money and say, oh, this startup company is starting, man, they promoted this, or, this may, or you can't go in a pyramid scheme for sure, right?
Just get rich quick schemes.
Yeah, you can't bother with that. So that's too risky, and that's outside of what you should do as a prudent, because you as a prudent man wouldn't take your money and put in a Ponzi scheme, eh? Trust must have full information about the investment before he makes it. So that means he must do somewhat
researching.
Yeah, so he should research before he makes the investment. And if he's not skilled in this area, he can now do what?
Seek professional guidance.
Right. And so what earlier in your chapters you would have been directed as to he has powers to appoint persons in his stead, right?
Yes.
Yeah.
So he can do an investment advisor, but once he's appointed these persons, what he must do?
He must still keep an eye on what they're doing.
Right, he must follow up. Right? So that's a part of his duties, to follow up to ensure that they are doing what they should do. Then he has what happens? He has a higher standard of care where he is purporting to be a professional trustee, carrying on this business and providing advice and managing trust funds. So the standard of care for a trustee who I may appoint as a friend compared to one who's selling his services is quite different. So you can't assume or say now that, well, I really didn't know, because you've now sold yourself to the world as a professional trustee. So I must assume that you know what you're doing. So you have a higher standard of care. So not only
I have a question about that.
Sorry. Go ahead.
I have a question about that. Sorry. In an instance where, say, I have a friend who is an investment manager or advisor, I suppose by appointing them as trustee, that would also cause them to be held a little bit higher in terms of the investment portion of my trust.
Well, now, it's according to how are you appointing them as a friend or as an investment advisor?
Well, as trustee, but I guess would you have to say I'm appointing them as trustee because of their investment
well, that's
knowledge?
Because now in order for him to be held to a higher standard of care, he would have had to be doing it in a professional capacity and not as a friend. So as much as he may be a friend, you would ensure that it's drawn up in business terms to know for it to be where we are clear on your role. Your role is as this person and not just as my friend. So I trust you enough to do it. I've referred the business to you, but I'm referring the business only because I'm aware of your professional capacity to invest. Then a trustee with a power of investment should undertake periodic reviews of the investments held in trust. So they usually do annual reviews, eh? So you look at your portfolio, look at your valuation, see what's going on, and seek advice where you don't clearly understand, eh? So where you have powers of investment, you must ensure that you undertake periodic reviews, and this is usually annually. So where the purpose of the trust is to provide financial assistance to the beneficiaries, it will be usually your investment should be in the best interest, and that's the best financial interest for these beneficiaries, where you're supposed to provide financial assistance. So what they say about this, UK courts have decided that not only where moral considerations do not affect the financial interests of the beneficiary should they be taken into consideration by the trustees. So what moral considerations you think would interfere now with your investments? What we talk about happening earlier with Ramol, you remember where they used the example?
Making decisions based off your own personal beliefs or feelings.
Right, so your moral considerations don't come into play, but where moral considerations come into play with the trust, it only can take place where it doesn't affect the financial interests of the beneficiaries. So you could take that into account where it does. So if the moral consideration of the beneficiaries investing in this would now trump the financial interest that they can receive, you must do what? You must put what first?
The interest of the beneficiaries first?
The financial interest. So if they invest in this liquor company or this number business, as long as it's legal, of course, and you say, well, you know, they really shouldn't be bothered with that, or it may be that, well, this beneficiary, you know, they're trying to live, they have certain religious aspects that this would now interfere with their religion because they don't believe in certain things. So let's use that as an example. They're highly religious. Do you think now, if they are totally against drinking liquor, should you now, and it's beneficial to them, would you now invest in liquor?
That's a bit tricky because it helps with the financial interests, but right, I guess.
So what you would have to do, you'd have to weigh it out and see what. I may have to look for another investment. I would say as much as it's beneficial to you, it would go against everything that you stand for. And so I'm trying to find something of equivalent value or something that could bring you the returns. But in your best interest, I don't think this is where you would want your money to be. Because it may be that you have a standing in society where you're such a religion, and now come to find out you benefiting from the very thing you're talking against, eh?
So I guess something like that would come heavily into play for like charitable trust then.
Yeah, so charitable trust, which you would be careful where you invest their funds, eh? So as much as you want them to benefit financially, you'd have to do a little research to find areas that they can invest in that won't conflict with what they're actually doing out there in the world. But your moral interests or your moral considerations don't factor into their benefits. So you don't place yourself in that position, because now what you've done, you've allowed your what to conflict.
Your professional and personal interest.
Right. So your personal interest is now conflicting with your duty as a trustee, and then that's liable. That's what you're going to be in. What? When your personal interests conflict with your duty, you are what? In what?
In breach of trust.
Yes, you're in breach now. So you got to ensure that you don't cross the lines, and you weigh it out and ensure that you cover all bases and aspects of what you're supposed to be doing. Any questions? Now, what are these? What we're looking at 1 through 5? What are they?
Trustee investment duties.
And they are supplemental to what?
Standard of care.
Yeah, your standard of care. So this is in addition to your standard of care, which is where you are required to act as a prudent man of business. You are to supplement your standard of care with these considerations, okay? Okay, who's going to read? Any questions before we go on to express powers? Who'll read express powers for us?
I can read it.
Okay, so you just go right up to number 3 of investment powers for us, please.
Okay, sure.
Thanks.
Express powers of investment. It is a general principle of trust law that express powers of investment within the trust instrument will be construed by the court according to the ordinary and natural meaning of the words used. Under the equitable principle that he who asserts must prove, a trustee wishing to argue that a particular investment falls within an express clause within the trust instrument must prove that it actually does. Harari Settlement Trust, 1949.
So before you move on, so the general principle is that express powers of investment within the trust must be construed by the court in accordance with its ordinary and natural meaning. So what ordinarily, what the words mean, ordinarily or naturally, is what the court will construe it to be. So the principle, the equitable principle, because remember, trust is a what? Creature of what? is a creature of trust. Trust law comes under which equity? Common law or equity?
Common law.
No, trust is equity. Yeah, trust is equity. So trust is equity because why is it equity? Because what happens in trust? Who's the legal owner of the trust?
The legal owner of the trust is the beneficiary. Well, the trustee first. The trustee.
The trustee is the legal owner. So equity has to step in and say what? As much as you're the legal owner, you know what happens.
You have to disperse ownership to the beneficiaries.
And
based on the trust deed.
Right. So in law, if I have a conveyance and my name is on it, I own it, eh?
Mm-hmm. Yes.
However, equitable principle says, I know what I'm only holding this for the benefit of another. So equity steps in, equitable law will step in to say, what is equity all about? What is equity about? Equity is on what? What equity is on? Fairness, eh?
Yes.
So equity is all about fairness. So equity says, is it fair that somebody passed you their property to hold in trust for them and you're now able to go away with the property knowing full well they only asked you to hold it and they trusted you enough to do it. So equity will consider what is fair and they will turn it over to who it rightfully was supposed to go to. So in times past, what happened? Somebody was going to war and they would have turned over some assets to another to hold for them until they come back or to take care of their family if anything happens to them. And what would have happened? They died in the war, and what the person may have done?
Take the property as their own.
Right. So they created the court of equity, which was under the chancellor, and the chancellor would say now, no, we have to step in and help this person out because it won't be fair for you to be allowed to take their property, knowing full well they trusted you enough to hold it for them. So likewise, the trust being an equitable creature, you would now come under equitable principle, and this is an equitable maxim. And what is the equitable maxim that we're referring to? He who you all did the maxims of equity, right?
Yes.
And so he who asserts must prove. And what it means as he who asserts must prove, what does that mean?
If you say something exists, you got to bring the evidence that it does.
Right. So if you say, you must prove it. So you are certain that this is so you have to prove it. You now the person who must prove it. So where a trustee is now wishing to argue that a particular investment falls within an express clause within the trust, he must prove that it actually does. So there are certain investment clauses which gives the trustees power to vary investments. And it is said to be an implicit power. So this power of investment means that they can vary investments. They could change it around or they can do as they see fit. The power of investment, which requires the consent of a third party, may also be allowed. Who may be the third party?
The protector of the trust?
Yes, the protector may be the third party, or we may have a power holder as well, eh? Now, what happens with this power? Where it is attached to a third party, do they have any fiduciary obligations?
No, ma'am. They're just
when they don't have the fiduciary obligations, everything falls on the trustee because the trustee is the only fiduciary relationship here. And due to its very nature, unless the context within the clause appears, it requires it. So where I'm taking instructions from a third party, I want to make sure that I'm It's expressly provided for in the trust because I'm the only one with the fiduciary obligation. And when I have these power holders or this protector giving me advice, am I on the hook for them telling me what to do with the power? With the investment?
Yes.
Would I be on the hook?
Yes, you would be.
Not if I require the consent of a third party.
Sorry, so again, you went out. Could you say that again? You went out on my end.
Oh, sorry. If I require the consent of a third party to make up an investment, would I be on the hook for getting their consent or making the investment?
Yes, you would be.
Why would I be if they're the person who's supposed to give me the consent to do so?
Well, you have the power to delegate or to get advice, but you still would be, not to say that they would not suffer any consequences, but you would still be, you're the trustee. So the job was given to you to oversee everything and you would be responsible for anything that may happen.
Right, but I have a power of investment, but I only have it as much as I can. I only can invest if I get a consent of the third party. What that means?
That consent will be inside the trust agreement, right?
Yes.
So that means you're doing it on the you have to do it. You have to do what they say then. If you do it on the consent of the third party.
Right. So I only can do it I can't do it without their consent.
So
am I responsible?
You wouldn't be on the hook. I don't think so.
No,
I would say no.
I can't be held responsible if I needed consent from somebody else.
Right, no.
Now, the problem with that is the third party has no fiduciary duties. So you can't hold them in breach or anything if it doesn't work out. Because they have no relationship. They don't have any fiduciary relationship with you. Only the trustee has. So in that instance, the trustee won't have to worry about them being on the hook for an investment which may fail based on the consent of the third party, because basically the third party is giving you the go ahead to say whether or not you should invest here or you should not invest. So that's the difference with, these are express powers now. So express powers within the trust instrument will be construed in its ordinary and natural meaning. And where the trust wants to argue that a particular investment falls within the express clause, he must do what? He must prove it actually does, eh?
Yes.
Yes.
And certain investment clauses may give the trustee's power to vary the investments, and that's an implicit power. And the power of investment that requires the consent of a third party may be allowed. However, that power may not have any fiduciary obligations attached to it unless it appears within the context of the clause. Like they would have put something attached that in a clause where they said, well, depending on the consent. So it has to be with the trustees' deliberations, or if they totally turn it over to the power holder, because the power holder may be an investment person, so they may have powers of investment, and they may be allowed to just make investments on behalf of the trust, and the trustee has to act on their advice or their instructions, and so the trustee will not be held accountable for their actions. However, there's no fiduciary relationship usually between these power holders and the trust itself, as it would be with the trustee in that instance. Any questions?
Question. So in this case, let's say they were to invest and they lose all their money, they go bankrupt or something like that. Who can the beneficiary sue in that case?
So they would have to now sue who? The power holder? And what you gonna sue them for?
Because I mean, let's just say they would, the trustees invested the money. I know they did it on the consent of the third party, right? So it's not their fault that risky investment and it went belly up. However, the beneficiary is still at a loss because now all their money is gone and they don't have no more income or whatever. Who can they turn around and sue?
So who? Nobody? They're gonna go after the power holder, right?
Okay.
But now what they're gonna say to the power holder? What they suing them for?
For allowing them to invest in a risky investment.
Right. So it can't be, what you can't say is breach of trustee.
No. Okay.
So you're gonna be suing them for what? Holding out to be a professional, or it may be a settler who's doing the investments.
Oh, okay.
Because he may retain the powers of investment, or he may be the power holder.
Okay, that's
or he
true.
may be the protector. So you see, that's where the consent of this third party is. That's somebody who the settler trusts to do their investments. So the trustee is off the hook in any event, eh?
Yeah.
Any other questions? Okay, let's go to investment powers in the Bahamas Trustee Act.
Okay, you said you want me to read up to number 3, or do you want me to just finish out?
Yes, up to number 3, and then the last person who didn't read first, yes, Stans, will take us home.
Sure. Investment powers in the Bahamas Trustee Act. Section 4 of the Trustee Act 1998 gives trustees full powers of investing and of changing investments as any beneficial owner who is absolutely entitled, which will be exercised at the discretion of the trustees and in addition or subject to the provisions within the trust instrument. Section 5 of the Trustee Act gives the trustees guidance on the exercise of the power of investment and requires trustees to make, change, and retain investments as a prudent investor would, which narrows the general standard of care of a prudent man of business. In making investments, trustees should consider the following. 1, exercise reasonable care, caution, and skill that an ordinary person would. 2, have regard to the suitability of trust investments in the context of the whole of the trust property with a view to obtaining an overall balance of risk and return reasonably suited to the trust. 3, have regard to the need for diversification of investments so far as the trustees consider it appropriate to the trust.
Okay, so Section 4 of the Trustee Act 1998, it gives full powers of investing and of changing investments to the trustees as any beneficial owner who is absolutely entitled. So when you're absolutely entitled, what are you?
Sui juris.
Okay, and you absolutely entitled. And it'll be exercised at the discretion of the trustees in addition or subject to the provisions within the trust instrument. So Section 4 gives you full powers of investment and of changing investments. Section 5 of the Act gives you guidance on the exercise of the power of investment and requires trustees to make, change, and retain investments as a prudent investor would. So it narrows the general standard of care of a prudent man of business. So you must do it as a what? A prudent investor would. So now you narrow down from not just being a business person, but you now as a prudent investor. And when you're doing this, you should consider you are exercising in reasonable care, caution, and skill that an ordinary person would. You would have regard to the suitability of the trust investments in the context of the whole of the trust property. So I could not, if the whole of the trust property is 100,000, should I take the whole 100,000 and invest in one item?
No.
No, I would have to consider the whole trust property and try to divest the property and diversify the portfolio as much as possible with a view to obtaining overall balance of risk and return that's reasonably suited to the trust. Having regard to who? When I'm looking for returns, to who? Who I'm having regard to? We talked about them earlier.
The beneficiaries of trust.
The beneficiaries, and what type of beneficiaries we talking about?
Capital beneficiaries?
No, we call them something else in this instance. We talk about their financial thing. Where the trust is to provide for the financial assistance, you remember that?
Okay, so
the beneficiaries, we have to consider, we have to bring in money to take care of these beneficiaries who require financial assistance. So we must make sure we consider all of these things when we make investments. We may need money to come every month, or we may need substantial amounts of money to pay school fees, or we may need to make mortgage payments or the like. So we have to consider all those things when we make an investment. So we can't tie up the funds and not have it available when we need the money for the financial beneficiaries. And then we must have it diversified as so far as the trustees consider appropriate to the trust. So you could diversify it where it suits the trust to bring the returns that you require necessary for this trust to be sustained. Okay, so you would do, when you exercise in the power of investment, what do you now? You must take care and retain investments as what?
As a prudent investor.
As a prudent investor. So you are now narrowed down the general standard of care of a prudent man in business, eh? Any questions?
Yes, please. I just wanted to clarify number 3, when it talks about considering it appropriate to the trust, that's where we would take into consideration that, like, the moral side of things, or things
right. So how is right? So is this appropriate for this trust and appropriate to the trust? So in Cowan and Scargill, was it appropriate for us to take the money from the trust and invest in energy when this is a coal, when the business of this trust is coal mining?
No.
So that's not appropriate for the trust. And diversifying the investment, why would it be appropriate for me to diversify it? Because I need income flowing from a few streams, because we have a lot of financial obligations in this trust, and we have a lot of financial beneficiaries who are depending on income from this trust. So we have to make sure that we have enough streams flowing that we could generate the income that is required, and we sustain the capital for the capital beneficiaries. Any other questions?
Thank you.
Okay. All right. So who's taking us home? Sans, please.
Section 5 and 2 outlines the considerations that the trustees must have in relation to deciding whether certain investments are appropriate for a particular trust, including the size of the trust property, general economic conditions, and the intentions and wishes of the settlor.
Okay, before you move on, so in deciding what investments to make, 5.2 outlines the considerations the trustees must have. So they must consider, first of all, the size of the trust property, what are the general economic conditions, and what were the intentions and wishes of the settlor. Where we will get the intentions and wishes of the settlor from?
And the trustee.
No, where we get that from?
Letter of wishes.
Right, so we may have a letter, or we may have a memo. And what may be the general economic conditions? So in the COVID environment, would it have been wise for us to invest in stocks that they sell, like in JCPenney?
No.
No, because most of those stores were closed down during COVID. Would it have been wise for us to invest in Walmart? Publix,
yeah, because Walmart was actually open.
Food,
right? So we would look for places that were generating during that period. We'd want to ensure we stayed with them. So we look at companies that were making masks at the time. Who was Pfizer? We would look into them. All of those drug companies who were making things that were related to the pandemic. So that would be considered the general economic conditions at the time. And then looking at all of those things, the size of the trust property, the general economic conditions, and the intentions and wishes of the settler. Go ahead.
Under Section 6 of the Act, trustees are not only empowered to select certain persons to provide investment advice and expertise to the trust provided that have the requisite knowledge, experience, and skill, but they may also be protected under law for any loss suffered by the trust in reliance on the advice of the selected investment advisor.
Okay, so they have powers of investment, but Section 6 allows them to select persons to provide investment advice. We talked about this earlier, right? And expertise to the trust. So once these persons sell themselves to be professionals in this area or they're investment advisors, Section 6 empowers the trustee to select these persons to provide such advice. They would now be, once they would have done what they're supposed to do, in selecting these people.
Do their research to make sure they're legit.
Right, and what they're supposed to do, these are supplemental to our standard of care. What is another thing they're supposed to do?
Do periodic reviews of what's going
on. And ensure they're doing what they're supposed to do, right?
Right.
So once they're doing that, they will be protected under law for any loss suffered by the trust in reliance on the advice of the selected investment advisor. So once they're doing what they're supposed to do, once they hold up their standard of care, they consider all of the supplemental things that go along with the standard of care, then they will be protected for any loss occasioned by the trust as a result of the advice they would have received from the selected investment advisor. Okay, go ahead.
Similarly, Section 13 of the Trustee Amendment Act 2011 allows a trustee the protection
Hello?
have properly discharged their obligations with regard to their selection, appointment of the investment advisor, and the continuing supervision of such advisors to ensure that such agents act in accordance with the provisions of the trust and with the same objective of preserving and protecting trust property from needless loss. Once the trustee properly appoints and supervises the agents to whom he may delegate investment or task, he may seek protection against liability for loss suffered by the trust due to actions of these third parties. Implicit.
Okay, so Section 13 of the Trustee Amendment Act allows a trustee the protection of law for any liability for loss occasioned by the trust where he has acted on the instructions or directions of a power holder or where he fails to act in the absence of director from the power holder with responsibility for investment. So that's important there. And we talked about that earlier. So he's protected from liability where there's loss, where he's acted on the instructions of a power holder, or where he fails to act. He's not done anything with investments because why hasn't he done any investment? Why would the trustee not
get the consent from the person he's supposed to get it from?
Right, or he may not have that power is now reserved to this power holder. So he will not act if he doesn't have direction from the power holder. So he's now protected under Section 13 of the Amendment Act. So He's only protected, the trustee is only protected where he's properly discharged his obligations with regard to selecting the advisor or appointing the, and where he continuously supervised act in accordance with the provisions of the trust instrument, and they do so with having the trust assets. So once the agents, he does his investment task, he may seek protection against liability by the trust due to the actions of these third parties for liability are suffered, where seek this protection. And they have you can have,
I don't know if it's just me, but you're going in and out.
It's breaking up.
Because my thing keeps shutting off, so it may be me. Can you hear me?
Now, yes.
Okay, where would he now be able to liability for loss suffered by the trust due to actions of
From the court?
he has to do this beforehand, remember? Some where he can get some there's any power.
Oh, you're still going in and out.
Can you hear me?
Yes, but you keep going in and out. You're breaking up.
Okay, let me try. Oh, goodness, what happened? See me any better? Let me see if I turn it up if that helps. Okay, let's try it. Better. Hello?
I think it's better.
I can hear you now.
As what doesn't he have a power to insure?
Oh yeah, so he could have insurance.
So where this power to insure is, where we'll find that?
It would have to be in the trustee. Is that what you're asking?
Don't we have this section somewhere in the Trustee Act?
Yes.
What section that was?
I'm not sure, but I know he has the power to insure himself other than breach of trust, and the trust would pay for the insurance.
Right, and what section it is, you all remember or no?
No, I don't remember.
Hello?
Is it 24? I just
yes,
looked.
section 24 of the Trustee Act.
Okay.
So you all have that on under appointment of trustees, and I guess, I don't know what unit that is. It's unit 5 in my book.
Okay.
They got the power to insure themselves against liability. Where he finds himself in that instance, he has he can against liability for loss suffered. Let's continue.
Implicit in discharging the investment's powers within the trust instrument or under that act A trustee must ensure that proper investment objectives are made and an investment strategy is created to invest trust property for the specific trust that he is administering. This is often done by the trust committee for a professional trustee. Once the investment strategy has been created and executed, the trustee must ensure that there are periodic reviews of the investments and the investment strategy in order to detect any changes in such investments which may cause loss. The trust administrator should ensure that the reviews and inspects the brokerage statements on a regular basis and provide the trustee or trust committee with the information regarding the particular investments, the terms of the trust instrument relating to investments and investment powers generally, pertinent information on the beneficiaries regarding their circumstances, and any advice or recommendations by the investment advisor.
Hello?
Well, hello. Sorry, I got cut out just now. Hello?
Hi, I can hear.
Okay. You were on implicit on
We can't hear you well. You're
when I went out. Can you hear me? Okay, give me again. Hold on. Okay, let me know if it's any better.
I can hear you now.
Okay, sorry about that. Okay, I think I lost you at once the investment strategy. Hello?
Hello, I can hear you.
Okay, I was saying at once the investment strategy has been created.
That's where we started. Yeah, we finished out the page.
We finished the page. I can continue to read it if you'd like.
Please, so I can go back over with you.
Once the investment strategy has been created and executed, the trustee must ensure that there are periodic reviews of the investments and the investment strategy in order to detect any changes in such investments which may cause loss. The trust administrator should ensure that he reviews and inspects the brokerage statements on a regular basis and provide the trustee or trust committee with the information regarding the particular investments, the terms of the trust instrument relating to investments and investment powers generally, pertinent information on the beneficiaries regarding their circumstances, and any advice or recommendations by the investment advisor.
Okay, so the trust administrator is now responsible to review and inspect the brokerage statements on a regular basis. and provide the trust or trust committee with the information regarding the investments, how it relates to the terms of the trust instruments, the investments, and how the investments powers are set out generally. It's important to have information on the beneficiaries, pertinent information, including perhaps their needs at this particular time, and any advice or recommendations from the investment advisor. All of these should be in his review in order for you to make decisions when beneficiaries may ask for, what may beneficiaries be asking us for?
The trustee minutes.
No, they can't get that. What they may be asking you for?
Oh, a statement?
Right, no, but what, if a beneficiary asking me to get what? Some income from the trust, what do you call that?
A distribution.
Right, we want a distribution. So he wants a distribution to be made to him. What I need to, in order to make an informed decision as to where I can make the distribution, I need to have this information, right?
Yeah.
Yeah.
So the trust administrator is responsible to ensure that this information is readily available in order for me to make an informed decision. One of the things what we say about that is I should know what the trust is at a glance, right? I should know the value of the trust at any point and whether or not I can make certain investments or whether or not I can make certain distributions as and when needed from the beneficiaries, yes? Okay, any questions? No?
No,
Y'all can hear me? Okay. So let's go over questions, the self-assessment. Trustees invest trust funds in order to provide an blank for the income beneficiaries or blank for capital beneficiaries, where we'll find that answer.
Income or capital for capital beneficiaries.
Okay, and where we'll find that?
On the first, on page 85.
Okay.
First sentence.
Okay, number 2, the trust instrument often provides blank to the trustees.
Express powers.
And where we'll find that?
Second sentence.
Okay. What are the general investment duties of trustees? Well, no, sorry. The primary duty of the trustees in deciding how and whether to invest trust funds is to blank and in the best interest of the trust.
Act for the benefit of the beneficiary and in the best interest of the trust.
For the benefit of the beneficiaries, where we'll find that?
The top of page 86.
Okay.
The bottom of page 85 and the top of page 86.
Okay. And everybody has the same page?
Yes, that's the same for me.
Okay. What are the general investment duties of trustees? Where we'll find that?
Page 86.
And what is it?
A lot. The trustee must not invest in risky or hazardous investments unless expressly provided in the trust instrument. A trustee must have full information about investment before he makes it. A trustee owes a higher standard of care where it is a professional trustee carrying on the business of providing advice and managing trust funds. And the trustee with the power of investment should undertake periodic reviews of the investments held in the trust. The review should take place at least annually. And where the purpose of the trust is to provide for the financial assistance of the beneficiaries, the beneficiaries' best interest will usually be their best financial interests.
Okay.
It has been this. Good.
Yes, that's fine. Under the equitable principle that he who asserts must prove, a trustee wishing to argue that a particular investment falls within an express clause within the trust instrument blank, where we'll find this answer.
Top of page 87.
And what is the answer?
They must prove that it actually exists.
Okay. Under Section 5 of the Trustee Act 1998, what considerations must the trustees have before investing?
That's on page 87. Exercising reasonable care, having regard to the suitability of trust investments related to all of the trust property and balancing risk and return, and regarding making sure that you diversify the investment as long as it's considered appropriate to the trust.
Okay. Must have suitability in making, should consider the following. So that's 1, 2, and 3?
Yeah.
1, 2, and 3 on page, I don't know what page it is in your book.
87.
Okay. What is the standard of care required under Section 5 of the Trustee Act 1998?
Would that be to act as a prudent investor would?
Right, so he must act as a prudent investor would. Section 13 of the blank allows a trustee the protection of law for any liability for loss occasioned by the trust, where such trustee has acted on the instructions or directions of a power holder or failed to act in the absence of a direction from a power holder with responsibility for investment. Where we'll find that answer.
Bottom of page 87. Trust Amendment Act 2011, sorry, 2011.
2011, Section 13 is Trustee Act, Amendment Act 2011. Okay, with regard to the legal protections under the law, a trustee will only be afforded such protections if they have properly discharged their obligations with regard to their blank of the investment advisor and the blank of such advisors to ensure that such agents act in accordance with the provisions of the trust and with the same objective of preserving and protecting trust property from needless loss.
Paragraph 2 on page 88. Selection appointment and the continuing supervision of such advisors.
Okay, hold on one sec. I wouldn't want to go contrary. Okay, number 10, once the investment strategy has been created and executed, the trustee must ensure that there are blank of the investments and the investment strategy in order to detect any changes in such investments which may cause loss, sorry. Where we'll find that one. Hello?
Paragraph 4, sorry.
Okay.
The answer is periodic reviews.
Periodic reviews, that there are periodic reviews. Okay. So we have reviewed that chapter. We know the powers of investment in the trust instrument. What are the powers of investment in the trust instrument? If they are not expressed, what happens?
The trustees have to use their discretion.
Or
they can follow the law.
They can refer to
the trustee, the guideline.
Right. Mm-hmm. In making these investments, what they should do? What is their ultimate goal?
To preserve and protect the trust property, but they have to act in the benefit of the beneficiaries and best interests of the trust.
Right. For both beneficiaries, which beneficiaries? Those both present
and future.
What is on what information can they obtain on the law relating to trustees and investments? What sections of the law now relate to trustees and investments? We have section what?
4.
Which section 4 of the Trustee Act deals with?
It gives giving powers
of investment and changing investments.
And then section 5 does what?
Gives guidance on the exercise of the power of investment and requires trustees to make change.
And what section 6 gives us?
The ability to appoint persons to provide advice and expertise.
Right. And what section 13 of the Amendment Act does?
Protect you from liability.
Where?
If you've been acting on instructions of a power holder, or if you didn't act because one doesn't exist.
Okay. And where would we find the principle dealing with the standard of care of a trustee in the handling of the business of the trust?
Is that also in section 5?
Where we'd find this, what case tells us about this principle of standard of care?
Well, I've gone to one.
Right versus gone.
Very good. And that is, what is that standard of care?
To act as a prudent man would if they were doing it for themselves or for someone they're morally bound to.
Excellent. And what about the principle that is derived on how the trustees decide how and where to invest trust funds for the benefit of beneficiaries and in the best interest of the trust? We will find that principle.
In case Cowan versus Cargo, 1984.
Excellent. Now, there's a narrowing of the standard of care and when it comes to investments, and what section of the act narrows it down when it comes to investment?
5.
Section 5. And what it narrows it down to?
Those 3 points of exercising reasonable care,
right,
considering the context of the entire trust property, making sure you balance risk and return, and then considering diversifying investments once it's appropriate to the trust.
And so we call them prudent man now, or what we call them?
Prudent investor.
Excellent. Okay, so we look like we have chapter 11 down pat. So you all get the gist of this pretty quickly. Yes? You all know 10 and 11 well, right?
Good. I would say good.
And you can now tie it back to what you've learned in the earlier chapters, yes?
Yes, ma'am.
Excellent. Any questions?
No, none from me.
Okay. And it's clear, the lesson is clear?
For me, yeah.
Yes.
Okay. I'm just making sure I'm breaking it down enough for you. Okay, so we'll review our 11 and then we'll move on to beneficiaries for the next week, Saturday. Okay.
Yes, ma'am.
Okay, if you have no further questions, then we can be dismissed.
Okay.
That's it?
Thank you. Yes,
Thank you too. Enjoy the rest of your weekend and be safe.
Thank you too.
Take care. See you all next week, God's willing.
assurances that the submission process are in line with the business